Okay. Good
Did
afternoon.
you want to record it? Is it already recording?
Yes, I just pressed the recording button. Yes.
Oh, good. Okay, thank you.
Good afternoon, everyone. My name is Ruby Ramirez, and on behalf of the Fresno Area Hispanic Foundation, we would like to say thank you for joining us for today's presentation. So before getting started, I just want to share a quick tutorial on how to use the chat box tools. You can use the tool by clicking on the chat icon if you're using a laptop, or by clicking the participant icon on the left side if you're using a tablet. You can also access the chat feature in your mobile device by tapping on the more option, and it'll give you the chat feature. Okay, we ask you that you please send us your questions throughout the presentation using the chat feature. And I also want to remind you that all participants will receive a copy of this webinar recording at the end.
Very good. And of course, the chat, oh, you're going to introduce people. What I was just going to say was we will get to the chat immediately after the remarks so that we'll handle those questions one at a time. Mm-hmm.
Okay. I would like to recognize I'm sorry, Beth.
Go ahead, I'm sorry.
I would like to recognize the following sponsors for allowing our organization to provide these weekly webinars to our business community. Thank you to Bank of America, Bank of the West, Chevron, Federal Home Loan Bank of San Francisco, Donna G. Sales, Wells Fargo, Tri-Counties Bank, and JP Morgan Chase, and of course, Union Bank. Thank you, supporters. So this is our agenda for today. Bill did mention we'll be having 2 more speakers added for today's presentation. I would like to share with you about the Fresno Area Hispanic Foundation. We are a nonprofit organization in the Central Valley with the mission to promote education and self-sufficiency by fostering entrepreneurship. At this time, our team is providing the following core programs remotely to our community: our virtual technical assistance program, our weekly webinar, such as this one, and our Marco Loan program. To learn more about our programs, please call us at 559-222-8705, or you can visit our website to sign up for our weekly webinars. Okay, so at this time, I would like to introduce our speakers for today, Bill and Sarah and Mia from the from the New Business Community Law Clinic of Berkeley Law. Thank you, Bill, for being here. I'll go ahead and allow you to share your screen.
Wonderful. Well, thank you, everybody. And thanks for hanging on as we got things started here. Hold on. Looks like, oh, it's saying I can't do screen sharing yet. Can you co-host me again? Let me try. Oops. Here we go. Now I got it. Great. Wonderful. Okay. So I think I'm right. Where did it go? It's right. Hit it open. Oh, this is it. I think that's it. Yes. And then that. Yes. And then we go to this. There we go. Wonderful. This should do it. And then the next screen. Okay, but all right. Looks like we're ready to go now. So welcome, everybody. Thank you for joining in here. This is being recorded, so if you need to check back later, we're going to go over a lot of information today. But yeah, do check back with the recording, and then of course do contact us if you need assistance. We do provide free legal help to entrepreneurs who can't afford an attorney, which is many people. And so at the end of the workshop today, you'll have some contact information on trying to get in touch with us. One thing I should highlight in particular is that we've started a new mediation program that is for tenants and landlords who are trying to come together, trying to work out, situations now when people can't pay rent or other situations around your commercial lease. This is a mediation service that's available in English or Spanish to commercial landlords and commercial tenants who are, interested in trying to work things out. And I should say that that's probably a good idea at this point because the court system is pretty much shut down because of COVID-19. And so there is a real incentive to try and come together in some kind of settlement at this point. And we can possibly help with that. So without further ado, let's get started. Just a usual disclaimer, and that is that we're giving you general information about the law. We put this together with the San Francisco Lawyers Committee and a couple of law firms that know things about landlord litigation and tenant rights. So just know that we're giving you general information, and we're not setting up an attorney-client relationship with you at this point here. So Sarah, let's give them a sense of what's going on.
Great. Good afternoon, everyone. Thank you so much for joining us. Just wanted to quickly go over the agenda. I'm going to start off today by just giving you kind of the most important advice, the biggest highlights that you can walk away with today. I'll go into types of rent and then hand it off to Mia, who's going to talk about some important lease clauses that you should keep an eye out for. And then Professor Kell will continue on with talking about some of the nitty-gritties of dispute resolution and eviction process, and then Mia will close us out with the top 10 reminders.
Very good.
So the most important advice that we could give to any tenant is to make sure that you get your lease agreement in writing. Your lease will only be enforceable if it's in writing. There's this whole doctrine called the statute of frauds, and it sets these boundaries for what should or shouldn't be in writing. It depends on the term and the amount of money that's being transferred. But kind of the bottom line is that your lease needs to be in writing for it to be legally enforceable. A handshake agreement, an oral agreement, those don't count. Anyway, you wanted to get it in writing because you want to make sure that you can avoid any disputes and misunderstandings. You want to iron out the contours of your agreement before you start paying rent. And that way, later on, if some issue arises, you can go back and look at the document and say, here's exactly what we agreed on. And this is particularly important in the commercial context. In the residential context, when you're just leasing an apartment to live in, there's a lot of county and state and federal laws that will kind of govern what that relationship will look like. In the commercial lease context, things are different. The government kind of assumes, well, these are two sophisticated parties coming together and it's a lot easier for them to kind of negotiate with each other. So there's not really that many laws that govern this agreement. So it's all kind of what you decide on in that contract. In that same kind of vein, it's really important to read and understand what it is that you're signing. You're going to be legally bound by the document that you sign. So it's important that you know each term, both to see that if it's something that you want to sign onto or so that you know what to expect if something happens down the road. It's really useful to have a lawyer review and explain this before signing. Lawyers dealing with these kinds of commercial leases have seen so many that they can tell you if something looks not standard, if something looks questionable, or it can tell you, hey, if you have this clause in here, this could happen, versus if you negotiate this way, this could happen. You can come visit us in office hours, and there's other resources to have a lawyer review a document like this. Mm-hmm. Make sure that you ask questions. Before signing the lease is really the time to make sure that you understand every little piece and that any questions that you have get answered before that you put your signature on that line. And try your best not to cave into pressure to sign. You want to ask for more review time just to make sure that you do your due diligence and you know exactly what you're getting into.
And folks, by the way, I do know that probably a number of you folks are already in leases. So, the question is, what can I do now if I'm in a lease or if there's a dispute about the lease? We also wanted to convey to you some things about if you are about to enter into a lease or you're thinking that's in your future at some point. We want to give you a sense of what to look for in this situation here. But I do know that a number of you folks are just like, hey, let's get to the dispute part because that's where I am right now. We'll definitely get to that. Don't worry about it. Okay. So go ahead, Sarah.
Sure. Yes, for those of you who are still sort of at the beginning of the process, the second most important piece of advice is to negotiate. Like we just said, the contract kind of defines your relationship. There aren't that many laws outside of it. So you can kind of assume that all those terms and clauses are negotiable and you want to ask. You have the most leverage before you sign the document when you're still negotiating. So it's a lot easier to ask for more before you start paying rent. for each clause, so each paragraph in the contract, you want to know the specifics. You want to know who is responsible for what and when and how much. And you can kind of think of it as a sort of depressing exercise of thinking of the worst case scenario for each paragraph. For example, what happens if the air conditioning breaks in your unit? There's only 1 month left on your lease. It's the middle of winter, so you don't really need it anyway. And it turns out that the cost to replace the system is $10,000. And you're moving out in a month. And the landlord says like, hey, like you have to pay for it. This is something that you would want it in writing saying, okay, the tenant will pay for air conditioning unless, and then list exceptions, one of which could be a scenario like this. The key is kind of to know and anticipate what's coming and to make sure that you negotiate for it and write it down ahead of time in the lease. This is where having a lawyer help you a little bit or looking at some other standard agreements can be really helpful. And you don't want to be surprised by costs that you don't expect. So even if it's a really competitive landscape and the landlord isn't open to negotiating very much, you at least want to carefully review those paragraphs so that you know what you can expect down the road and kind of plan for it. Really quickly going over a few types of rent, and this may be review for some of you. There's always the base rent. So this is the minimum monthly rent. It's usually based on square footage. So this is where it's helpful to go in and take measurements yourself. You want to make sure that your landlord and you both agree on the size of the space and then note it in the lease so that you are very, very sure what you're going to be owing that landlord. There are also different kinds of net leases. So this is when landlords pass through costs to the tenant. There's a single net, so the landlord has the tenant pay property taxes, double net, which is property taxes plus building insurance, and then triple net, which is property taxes, building insurance, and operating expenses. And this can include things like additional taxes or custodial crew or even maintenance of kind of common spaces. A few other questions that you might want to consider is a question of when you have to start paying. So there's something called the commencement date, which is when your contract begins and your term begins. And then separately from that, there's a rent start date, which is when you have to actually start paying rent. And those are different things. You also want to make sure that you know exactly what's included in the rent and what is being passed through to you. And then you want to ask questions about the future of the rent. So does the rent increase by a fixed amount every year, let's say 2%? Particularly now in the time of COVID, one of the questions you might want to ask is, do you have to pay for rent even if you can't occupy the space and run your business? So that's a question that you could ask in advance. A few other things. The term is the length of term that you're entitled to occupy the space. Again, not necessarily when you're actually occupying it, but when it's yours to occupy. There's a clause that we recommend is included. It's a subordination and non-disturbance clause. So imagine that your landlord sells the building and you're not sure whether or not you're still going to have a space to rent under this new landlord. You can have a clause in your contract that will require that new landlord to honor your existing lease, and they won't be able to kick you out just because it's a new landlord. And then there's also something called options. Basically, the option to extend your term. This is something where you can write in saying like, okay, 4 months before my term is due to expire, I want to have the option to extend that term. And if I say it within this time window, then I'm allowed to extend my term. So it's something where you want to make sure that you know what window of time that option is. You want to send a written communication that makes it very clear that you're exercising your option. This is language that you can look up online, but it's simply saying, pursuant to this part of the contract, I'm extending my term and renewing my rent. And then you also want to understand how the rent will be determined for the extension term. So is it something where you'll be paying the same rate of rent? Will it be prorated because you're paying for a shorter period of time? Kind of additional questions that you want to ask. And then if there's no option to extend, but you still want to renew your lease, and there might be new rent, so something that you haven't decided on beforehand. Something that could be helpful is determining the fair market rent, kind of looking around and seeing what are similar buildings in a similar area and how much are they going for, and giving your landlord evidence and saying, hey, here's comparable units, and here's the fair market value. You could, if you're in a situation where the property value is rising and neither your landlord knows how much it'll cost in a few months, you can say something like, the rent will be determined by either the fair market value or 15% more than the current rent, whichever is less. So that's sort of a compromise on both parts. A few other things you can do, you could ask for a shorter extension term and again, have it prorated and say like, I'll lease it for an additional few months, but I want a lower rent or I want the same rent, or I'll agree to increase in a rent, but I want it to be less of an increase. You can also offer to take more or less space to downsize or upgrade and then adjust the rent accordingly. Okay, I will pass it off to Mia.
Hi everyone, I'm Mia. I'm happy to be here with you all and sorry for the technical difficulties earlier. So picking up where Sarah left off, I just wanted to reiterate that we really encourage you to have as many parts of your lease and the agreement that you'll have with your landlord in writing as possible. So as we keep going here through the clauses, these are kind of specific ideas for specific things that having in your lease will be beneficial. And as Professor Kell said, he'll be getting to the kind of mediation component later on. But one great reason to have things in writing is not only, to have a legally binding agreement with your landlord, but also to have kind of the expectations set up front so that everybody is on the same page. So Sarah just talked to us about the kind of overarching components of the lease that you might think about, like how long it's going to be for and what you do if you want to extend your lease. Now I'm going to talk about some components of the lease that are more specific to the actual space you're going to be in and how to think about setting terms with your landlord so that everything is fair on the kind of details of the space that you're going to be in. So the condition of the premises is a big one. You definitely want to inspect the space before you agree to lease it. And here are some examples of things that we think you should look out for, such as heating and air conditioning. You want to make sure everything is working properly and up to code. And if there are any issues, you should definitely let your landlord know, these repairs need to be made before you take the space. And so having that in writing in your lease is really helpful. You can even have an independent party come and help do an inspection just so it's not, it seems to everybody like it's fair. And then one thing to look out for in a lease agreement is this as is clause. So legally what that means is if you say, if you sign, I accept this property as is, it means even if there are problems or things like that, you just have to deal with them and the landlord isn't going to have to fix it or anything. And so since you're probably going to have to agree to that. What we encourage you to do is to have the landlord spell it out in the contract what exactly as is means. So that, say the building is in compliance with all laws, say you're not going to be responsible for the costs associated with fixing it if the building hasn't been in compliance with the laws, and anything else about the condition of the building, put that in the lease before you agree to take it on. It's vacant, there's not another tenant already in there, it's broom clean, everything is in working order, like we said. Then the next thing that we'll talk about is improvement. So let's say either hopefully not before you take over the building, but once you're occupying the building, what do you do if something needs to be improved or fixed? So if the landlord is going to be planning to improve something, put the deadlines and put all of the kind of timeline into the contract. You just want to make sure that, if the landlord has agreed to improve something, they finish it before you move in there. Or, you don't want to have to be paying rent when you can't move in yet because the landlord is still trying to finish something up. So that's for landlord improvements. And then for tenant improvements, it's really helpful if you can think about if there are things that the landlord can provide to you to help you do improvements, because obviously if you do an improvement, it might be something that benefits both you as the tenant and also the landlord if they're going to keep that kind of improvement in the space even after you leave. So talking to your landlord about if you can have an allowance for improvements, and then, yeah, let's say you leave your lease, is there any part of the improvements you can take with you, or does everything have to stay? Again, we just are encouraging you to, on your end, to think through all of these steps before you sign the agreement, and even better to discuss it with your landlord before you sign the agreement. So one major category of improvements that is worth thinking about is the ADA. And the ADA is the Americans with Disabilities Act, and it says there are certain accessibility standards that all buildings have to meet. And so, that is just a requirement. You have to change existing buildings that aren't meeting the ADA requirements, and if you alter the business space, you also need to keep your updates up to date with the law. So those types of renovations can be really expensive. And the problem here for the tenant is that if someone sues you because the building is not ADA compliant, both the landlord and the tenant can be sued for non-compliance. So you just want to be careful that this is spelled out in your lease. Landlords might want to pass the costs of ADA on to you. So say the building isn't compliant. Some of the areas that are come up might be like the entryway of the building, if there's stairs or something, if there's elevators, if there's restrooms, all of those things are going to have to be compliant. And you want to make sure that if those things aren't compliant, the landlord doesn't just hold you responsible for fixing that and upgrading it, because it can be really expensive. So one thing that we recommend is before you even sign the lease, try to get a compliance inspection, and put it in the lease too, who's even going to pay for that inspection. And so try to get the inspection, see if there's any costs that are going to be associated with upgrading a building that you're going to take possession of for ADA compliance, and then put it into the lease, that the landlord is going to pay for that, and it's all going to be ready before you take on the building. So you should have had an inspection. The law requires the landlords to disclose whether an inspection has taken place, but it's really in your interest to follow up on that and make sure that that's happened before you take ownership of the building. And then, so if in the course, normal course of using the space, there's any maintenance and repairs, as with everything else, we just encourage you to think about what might come up and who's going to be responsible for paying for it. As you can see here, it's kind of the default that the landlord would be responsible for structural elements, and then the tenant would normally be responsible for the interior. But it can be a really good idea to just go through the building in detail and be really specific about what structural elements is going to include. So here's some examples: the roof, load-bearing walls, the foundation, and then what is going to be included in the interior premises that it's going to be the tenant's responsibility to include. So if it's fixtures or business equipment, and just having all of the details written down, as I've said, is good, both for the legal obligations of your contract and also for your just kind of baseline understanding with your landlord. So if you get to a dispute, which hopefully you won't, at least you'll have a little bit more common ground at the beginning. So those are kind of the some examples of things about the space we just want you to think about before you enter into a lease. And then I'm going to talk about sort of some exit options or other components of the lease to think about. I'm going to talk about assignment and subleasing. So assignment is you're trying to take whatever is left of your lease and give it to somebody else to take over. So an example here is you sold your business. If you sold your business, can you say, okay, well, I have this building lease and the buyer of my business is just going to take over the building lease as well. You're probably going to need the landlord's consent to do that. And a really important aspect here is that the new tenant, so whoever you sold your business to in this case, or whoever took over your lease, they're going to pay the rent directly to the landlord, but you're still going to be responsible for the lease. So basically, if they don't pay, if your new tenant doesn't pay, it's going to be on you to pay unless you can get the landlord to agree to release you from that obligation. So definitely thinking through these kind of possibilities of, how things might change that you're not expecting now, and try to put some of these terms into your lease. With this one, you just want to have it in the lease that maybe you have the option of assignment, so you can assign your lease if something changes in your business. So assignment is the complete transfer of your lease. So, you have 2 months left or whatever, and you're going to give that over to somebody else. That's assignment. Then another way of kind of moving your responsibility in your lease is subleasing. So subleasing would be a partial transfer of the remaining lease. So an example could be like in COVID, maybe you have a big indoor space, but you don't need it right now because you're doing outdoor dining. And so is there someone who could use your part of your indoor space, meanwhile you still use another part of it? So that would be a sublease. It would be you're kind of bringing in someone else who also takes part of the lease from you, and they would pay the lease or the rent to you, not to the landlord. But the important thing to note is that you would need your landlord's permission to do this. So trying to make sure that it's in the terms of your lease with your landlord that you have the option to do sublease if that's something you might need, or if you have the option to do assignment, just so you have a little bit more flexibility in what your options are depending on how things change. Oh, one other thing about subleasing is that since you will still be paying the rent to the landlord and the new tenant will be paying rent to you, you're kind of taking on a risk there, because if the other tenant, causes problems or doesn't pay their rent or whatever, you basically are their landlord, and so you have to deal with that. So it can have the benefit of bringing in a little bit of extra income, but it can be a risky option for you. And then the last thing that I'm going to cover here is insurance. That's another thing that is good to work out and include in your lease. So you probably want to have this insurance for your business, the commercial general liability insurance. And specifically what we're looking at here is in your lease, try to make sure that you have this waiver of subrogation. And what that is going to mean is that you don't want, the landlord is probably going to have their own insurance, and you don't want their insurance to come after you instead of just going to the landlord's insurance. So this is going to protect you to make sure that your insurance is for you and the landlord's insurance is for the landlord. And if the landlord's insurance has a problem, they're not trying to pass it on to you as the tenant. So that's why we want to see that waiver of subrogation in the lease. And Professor Kell's going to take it from here.
All right, well, good. Well, thanks, Mia, and thanks, Sarah. That's great. So just a couple of things before we get to some of the sort of dispute aspects of things. There is this thing called zoning, which maybe you've heard about. And what it is essentially that your local government has the power to say, you know, certain places in our jurisdiction can be used for certain, you know, business uses. And so, for example, certain neighborhoods will be seen as only residential, or maybe combined residential and commercial. And so when you are looking for a space, just make sure that you are renting in a place that will allow you to basically do your business. So where do you find this? Normally it's on your county map. The zoning power is then exercised by the county government. Sometimes if it's a bigger city, they'll have their own zoning map to look at. And it's sort of a multicolored kind of thing. You'll see it on their website there. And you should just know that if you are doing a use, you know, like commercial use in a neighborhood where it says no commercial use, then you need to get a variance. That means to go to the city or county zoning department and say, hey, look, I'm doing this in my home, you know, or I'm doing this in the space here. Can I get a change in the space? Because a variance is actually a change going forward, permanent actually. And the idea is you at least need to give your neighbors notice that it's going to change, because that could affect them, you know. Now, if you just needed something for a short period of time, then of course, you know, that's more like an exception. A variance is changing the zoning status of the particular piece of property going forward. Okay, well, let me tell you now a few things about, you know, disputes. What happens when there is a dispute about whether the lease is being followed or not? Well, the whole thing on the landlord side is default. They think about, you know, have you fulfilled everything in the contract? And of course, you know, if the landlord does something doesn't do something they're supposed to do, they could be in default in this situation. There's economic default, which usually involves, you know, failure to pay rent or stuff. But then there's also potentially non-economic default. That means, like, let's say the landlord pledged to pick something for you, you know, before you move in, it's not fixed. Okay, well then that's a breach if the landlord did not fulfill their promise. Now, usually in this situation, there's some kind of notice and cure period. So this is pretty common. It'll say, for example, you need to pay by the 5th day of the month, you know, for the coming month, or maybe you pay in arrears for the previous month. But then it'll say, you know, if you don't pay by the 5th day, then you can pay late with an additional fee, you know, additional penalty. Now that, you know, then if you go ahead and pay that and you pay the additional penalty, there's some dispute sometimes as to whether you've actually fulfilled the contract. My sense of the safe way to do this is to just assume that any time you can't fulfill an obligation in the lease, that the landlord does potentially have the ability to claim you are in default. So just, I would just say, you know, don't even mess with it if you can. Try and get your rent payments in on time, or, you know, let the landlord know, gee, this month I need a couple extra days. Is this going to be a problem? And then you can sort of gather from their response as to whether they really are going to hold this against you. But you see, the thing is, when I gave you that example of paying by the 5th, and then if you paid on the 6th, then you paid this extra penalty, that's fine. It's just if the landlord then wanted to get you out, they could say that you didn't fulfill the terms of lease as written. And, you know, the problem is for the landlord is there's really no damage from that, because you paid this rent, the penalty for that. But some landlords get really tough about this and are looking for ways to get rid of you. And so just, you know, don't give them a reason to do it, if you can possibly avoid it. But good communication with the landlord usually is something that will you know, take care of smooth over a lot of these potential problems here. All right, well, if there is a dispute that comes up, I mean, there are a couple of ways to handle it. Court is usually the most expensive, and it's also the probably the longest time period, especially in the time of COVID here, because many courts are closed. Many courts are saying no more commercial evictions because actually Governor Newsom gave them that power that the local counties can say, look, we just aren't going to be processing evictions at this time. So check your local county to see whether they've banned evictions of any sort. But here's some other options. And as I said, we have this new service that might be helpful to you. It's called mediation. So mediation is a situation where if you and your landlord aren't able to sort of come to terms, then an independent person, independent panel of people or something like that, can listen to both sides and then suggest a solution. They're also potentially there to help draft a settlement of some sort, but that's distinguished from something called arbitration, where arbitration is really private court. It means that the parties have agreed that the arbiter, who they agree upon, is going to actually be able to decide this. We'll again listen to both sides and then actually make a decision that the parties already in advance have said we will agree to. And then often, one of the winning party in that situation will take the decision of the arbiter to court to be contained in a judicial order. It usually doesn't involve a hearing or anything like that. So arbitration, does make sure that you get out of there with an agreement, with some sort of settlement. Mediation is more helping you get to an agreement. Usually in mediation, there's no lawyers. Arbitration, there may be some lawyers involved. Okay. So let's see, here's some things to know about. If there is a dispute here and if the landlord wants you out, there may be a notice to vacate the premises. It's a 3-day notice to either pay rent or quit. Okay, and it's usually, takes into account the weekends or the court holidays or stuff. And the idea is that if you don't pay the rent, then eviction will follow. Sometimes there will also be other reasons that brought to this. If, for example, the lease said that you couldn't do certain activities, but you're doing them anyway, then that could also be a reason for a notice to quit. And then just know that the lease usually says what the notice period is for giving you, some notice about these proceedings here. And just here's the thing: the landlord in a month-to-month tenancy, month-to-month lease, all they have to do is give you a 30-day notice at any time for any reason. I mean, it can't be a legal reason like, they don't like your religion or they don't think you're too old or something like that. But generally, those things I was saying before, if you can't pay on time, even if you paid that penalty that went with it, they can just decide, look, I just don't, I want somebody who's paying on time all the time. Sorry, 30-day notice to get out. But that's the reason that you want a lease that has a longer term than month to month. It's so that the landlord can't just sort of step in and say, we don't like you anymore, sorry. So let's see the eviction procedure. There's a 3-day notice. They give you service. Usually the sheriff shows up and gives you a notice here. But you should know that once you pay, that'll take care of the notice if there is a, outstanding balance of some sort. Tenant usually has 5 days to answer with the court. And you should, of course, add your defenses saying you did pay. Here's my receipts that show you did pay. The thing is that if the tenant doesn't answer, then the landlord can ask the court to, for possession, and then you're definitely out at that point, potentially. And the court has to set a trial date within 20 days of receiving your answer. All right, well, if the parties decide to settle, then of course, make sure the settlement papers specify, the date and times, and that the eviction will not go on your record, because that's also a way that it's tough for some people who've been evicted to get a new lease. They have to, disclose that they've been evicted. Now, if the landlord does successfully sue to get you out, we'll expect you got about 2 weeks to get out of there. The sheriff will come in, and as soon as the sheriff locks you out, then essentially you can't get in anymore. But you do have 15 days to claim any property that was left on there. All right, well, lease negotiations. This is sort of the final thing we want to cover. You should just know that landlords before COVID-19 had a lot of leverage because, they could file this notice to pay or quit. They could sue then for if you stayed in possession, even when, even, if you didn't pay the rent, there's very few defenses that you'd be able to bring up. And, they can even file a separate lawsuit for damages as well. So, when the courts were open, landlords generally had good leverage here. The thing is that now, as I said, counties have imposed moratoriums. There's a lot of economic uncertainty about, well, gee, if I get this tenant out, me as landlord, am I going to be able to re-rent the space? Maybe people aren't really looking to let spaces, rent spaces now. So as I said, some courts, like our Alameda County, just won't even hear evictions now. Some other counties are easier on that. But here's some general things to think about. Landlords don't tend to want empty spaces, and they do want some amount of cash flow, even if it's less than what you had before. And of course, tenants in this situation do want some rent relief and certainty as to what they are going to be paying. So here's some different modifications we've seen so far as people are negotiating these things. Certainly a deferral of rent. Okay, I owe this much money in back rent. You don't have to pay that. You don't even have to pay interest on it until X date. You work that out. Then there may even be some forgiveness of your rent. There may be an application of your deposit, your security deposit, to cover unpaid rent. Here's some other more creative things. You could set it up potentially as, look, I'm not having any money coming in right now, but when I do have money coming in to a certain amount, then every amount that I get in, a certain amount is going to go to retire the debt of the rent that's still piled up here. Usually there's some conditions that are added, that you have to continue in business and not file bankruptcy. You have to continue to pay. If for some reason you don't continue these things, then, there could be a clawback that basically says, look, we agreed on the settlement here and you're not fulfilling your part of the bargain. Okay, well then, the original obligation here is reactivated. So now, one of the reasons it's very difficult to predict here is that, normally, like if your lease is up, let's say you have a lease now that's up in January, yeah, you could negotiate something and say, well, yeah, I should be able to pay better after the first of the year, or I can get my finances together, stuff like that. Nobody knows when we're going to be back to normal. So, very hard right now to sort of say, look, I think it'll be better in 6 months or something like that. It's very hard to tell. So here you should just know this is what your landlord is thinking about when they're coming to try and work something out with you. They're thinking, gee, what kind of a business is my tenant in? Are they actually even going to be able to start? I mean, they're, I don't know, some kind of like they're a masseuse or something like that. Boy, masseuses touch people, and it's very easy to get COVID when you touch people. So maybe that's a risky business I don't really want in there. And then they might be thinking, gee, are you going to file for bankruptcy? Which means that then they get in line behind a whole bunch of other creditors. If I do get this person out, what's my prospects for re-renting the space? Landlords will probably have their own investors or mortgage that they have to satisfy, so they may get in pressure that way. So what we're seeing really is a preference, though, to leave the tenant in place, but keep some money coming in. And then always they have this ability when the courts reopen to come back and say, well, look, there's still this outstanding amount of rent, and we need, we're asking for it now. So there are some defenses, though, that tenants have. Maybe, for example, there was a specific provision in the lease that the landlord breached. They never gave you, they said they would fix the air conditioner. Okay, well, right now that might not be an issue, but in the summertime, that's a big thing. And so if they never did that for you and it's starting to get hot and stuff, gee, that's a specific reason that potentially you could say, look, he violated the lease first. There's also this thing called frustration of purpose. Yeah, let me see another example of that. Oh, yeah, here we go. I'm running an ice cream shop, and they, landlord said that he would fix the freezers before I came in. The freezers still don't work, and so how could I possibly run an ice cream store in a place with broken freezers? That's just, frustration of purpose there. Now, tenants might argue force majeure. Force majeure means, look, nobody could understand or predict that COVID would come along and knock all our businesses out of the water like this. Force majeure is working sometimes with people, most times probably not, because everybody is affected by this now. So probably not a means to getting out of your lease. Here's an important one. You know, the landlord has responsibilities. If you can't pay, if you have to get out, that they have to try and re-let the place. So if they are sitting on their hands and going, oh, gee, you know, nice space here, but you are the one who's responsible for it. Well, no, they have to make efforts, reasonable efforts, to try and you know, re-let it to somebody else so that you aren't still owing on stuff. But there are some limitations by this civil code section that you want to take a look at, because sometimes that means that landlords don't have to make so many efforts. Now, there is this other thing that you should just know. Remember I said that the courts are sort of constrained right now? If you were instead rented out a place under what's called a deed of trust, well, that's sort of a short form kind of eviction process that you might be subject to there. A deed of trust is technically, let's say I had a piece of property and you wanted to rent it from me. I could say, okay, let's set up a trustee to hold the property, and then you, tenant, pay the trustee, who then pays me, and the trustee will let you have possession of the property there. Well, if then you stop paying and the trustee says, hey, they haven't been paying me, all you have to do then is say to the trustee, look, you revoke the right of possession here, and then it's much easier to get the tenant out without even going to court about it. So I guess what I would say overall is we're seeing that litigation right now is not a good option for landlords generally. It's not going to resolve within, you know, maybe even a year or a couple of years. So landlords may not want to take this on, you know, as a litigation kind of thing. So we do have a few other resources that you should know about. There is this Lawyers Committee Fair and Just commercial lease that you can attach. If you, you know, what we'll do is we'll send a copy of this to Ruby, so she can send that out with the PowerPoint here. You know, there's also a couple of good NOLO press legal resources that are always really helpful. They're good lay-friendly materials there. Let's see, I guess then we're to our last sort of 10 takeaways there. Who's going to do this? Is this Mia?
Yeah, so I know you all thought that you were done with this when Professor Cal got to the juicy stuff, but just knowing that there's a lot of components to the lease agreement you may have with your landlord, and since the litigation is probably not going to be the right approach now, it could be a good idea to just go through your lease, check what the terms are, and see maybe if there are places where you could have a conversation with your landlord based on what you agreed to at the beginning. So just some of the things that we went over at the beginning, you want to write everything down, read all the terms in your lease before you agree to it, and make sure you negotiate if things aren't in there aren't working for you. Be sure you know not only what the rent is, but also what that includes, and know about how long your lease is allowed to go for, and if you have options to extend, or if you want to leave or change your position. Make sure that you double check the condition of the premises, which includes any ADA compliance. Agree with your landlord about who's paying for improvements, who's fixing or doing maintenance that's needed. Make sure you have insurance, and you want that waiver in your lease that we talked about so that your landlord's insurance isn't coming after you. Check in there what your assignment rights are, what your sublease rights are, and try to provide for those as much as you can. And then, as Professor Cal said, you want that notice and cure period, so if something goes wrong, you have the opportunity to fix it before you're just considered breaching your lease.
Great. Well, this is how you contact us. So probably the best place to go is to go to this website here, www.law.berkeley.edu/NBCLC. That's where you can sign up. Whoa, shoot. That's where you can sign up for office hours, where you can talk with us for free for 45 minutes on a regular basis, Monday, Wednesday, 11 to 2 p.m. And then, of course, we'll be back here on third Friday again to talk with you about another topic. So at that point, just talk with Sandra or Ruby to sign up for those office hours when they come around again. And then you can also email us anytime at this newbusinesslaw@berkeley.edu. Okay, well, we talked a lot. Gee, thank you, Mia, and thank you, Sarah, for covering these things. We're around for some questions now if people have them. Mia, I know you have an office hour appointment you got to go to, so thank you. You can sign off when you need to there. But so let's see what questions people have. If anything, go ahead and raise your hand or just speak up if you have a question. I didn't see any in the chat. Oh, wait a minute, we got one in the chat. Wait. Oh, good. Thank you, Veronica, for identifying the zoning resource for the city of Fresno. Thank you. Okay. Other questions that people might have? Yeah, go ahead and unmute yourself if you need to. Should be able to unmute yourself. Anything else, guys? We will, again, make this recording available and the PowerPoint, and then also the fair and just lease that Lawyers Committee has created. We'll make sure that Ruby has that and can put that up here. Looks like, here, let's make you a, I don't know why I gave away the host here. Let's see, make you a host. Yes, here we go, Ruby, you're back in there?
Yes, thank you.
Mm-hmm.
Okay, I didn't see any questions, but if people do email us with questions, I will let you know. So you can get in contact. There's another slide with the contact information for the Berkeley Law team. And I want to share that we do have a QuickBooks webinar series. The next upcoming webinar is scheduled for December 2nd and December 9th, beginning at 1:30 p.m. It is a 2-hour presentation. It ends at 3:30 p.m. And this is a slide where you can contact the Fresno Area Hispanic Foundation if you have any questions. Again, you can call us at 559-222-8705 or to get in contact with the Berkeley Law team. Thank you, everybody, for joining us. And thank you, Bill, for your great presentation, and Sarah and Mia for joining us.
And everybody stay safe. And do contact us if you're looking for mediation services. That's something that we can possibly help with directly. So yeah, everybody stay safe and be healthy and have a good weekend.
You too. Bye-bye.
Okay.